3 US 386, underscore 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 underscore. 3 Doll. 386. Calder et wife. Versus. Bull et wife. Supreme Court of United States. Chase, Justice. The decision of one question determines, in my opinion, the present dispute. I shall, therefore, state from the record no more of the case than I think necessary for the consideration of that question only. The Legislature of Connecticut, on the 2d Thursday of May 1795, passed a resolution or law, which, for the reasons assigned, set aside a decree of the Court of Probate for Hartford, on the 21st of March 1793, which decree disapproved of the will of Norman Morrison, the grandson, made the 21st of August 1779, and refused to record the said will, and granted a new hearing by the said Court of Probate, with liberty of appeal therefrom, in 6 months. A new hearing was had, in virtue of this resolution, or law, before the said Court of Probate, who, on the 27th of July 1795, approved the said will, and ordered it to be recorded. At August 1795, appeal was then had to the Superior Court at Hartford, who at February term 1796, affirmed the decree of the Court of Probate. Appeal was had to the Supreme Court of Errors of Connecticut, who, in June 1796, adjudged that there were no errors. More than 18 months elapsed from the decree of the Court of Probate, on the 1st of March 1793, and thereby Caleb Bull and wife were barred of all right 387*387 of appeal, by a statute of Connecticut. There was no law of that state whereby a new hearing, or trial, before the said Court of Probate might be obtained. Calder and wife claim the premises in question, in right of his wife, as heiress of N. Morrison, physician. Bull and wife claim under the will of N. Morrison, the grandson. The counsel for the plaintiffs in error contend that the said resolution or law of the Legislature of Connecticut, granting a new bearing, in the above case, is an ex post facto law, prohibited by the Constitution of the United States, that any law of the federal government, or of any of the state governments, contrary to the Constitution of the United States, is void, and that this court possesses the power to declare such law void. It appears to me a self-evident proposition, that the several state legislatures retain all the powers of legislation, delegated to them by the state constitutions, which are not expressly taken away by the Constitution of the United States. The establishing courts of justice, the appointment of judges, and the making regulations for the administration of justice, within each state, according to its laws, on all subjects not entrusted to the federal government, appears to me to be the peculiar and exclusive province and duty of the state legislatures. All the powers delegated by the people of the United States to the federal government are defined, and no constructive powers can be exercised by it, and all the powers that remain in the state governments are indefinite, except only in the Constitution of Massachusetts. The effect of the resolution or law of Connecticut, above stated, is to revise a decision of one of its inferior courts, called the Court of Probate for Hartford, and to direct a new hearing of the case by the same Court of Probate that passed the decree against the will of Norman Morrison. By the existing law of Connecticut, a right to recover certain property had vested in Calder and wife, the appellants, in consequence of a decision of a court of justice, but, in virtue of a subsequent resolution or law, and the new bearing thereof, and the decision in consequence, this right to recover certain property was divested, and the right to the property declared to be in Bull and wife, the appellees. The sole inquiry is, whether this resolution or law of Connecticut, having such operation, is an ex post facto law, within the prohibition of the federal Constitution? Whether the legislature of any of the states can revise and correct by law a decision of any of its courts of justice, although not prohibited by the Constitution of the state, is a question of very great importance, and not necessary now to be determined, because the resolution or law in question does not go so far. I cannot subscribe to the omnipotence of a state 388*388 legislature, or that it is absolute and without control, although its authority should not be expressly restrained by the Constitution, or fundamental law, of the state. The people of the United States erected their constitutions, or forms of government, to establish justice, to promote the general welfare, to secure the blessings of liberty, and to protect their persons and property from violence. The purposes for which men enter into society will determine the nature and terms of the social compact, and as they are the foundation of the legislative power, they will decide what are the proper objects of it. The nature and ends of legislative power will limit the exercise of it. This fundamental principle flows from the very nature of our free republican governments, that no man should be compelled to do what the laws do not require, nor to refrain from acts which the laws permit. There are acts which the federal, or state, legislature cannot do, without exceeding their authority. There are certain vital principles in our free republican governments, which will determine and overrule an apparent and flagrant abuse of legislative power, as to authorize manifest injustice by positive law, or to take away that security for personal liberty, or private property, for the protection whereof the government was established. An act of the legislature, for I cannot call it a law, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority. The obligation of a law in governments established on express compact, and on republican principles, must be determined by the nature of the power, on which it is founded. A few instances will suffice to explain what I mean. A law that punished a citizen for an innocent action, or, in other words, for an act, which, when done, was in violation of no existing law, a law that destroys, or impairs, the lawful private contracts of citizens, a law that makes a man a judge in his own cause, or a law that takes property from A and gives it to B, it is against all reason and justice, for a people to entrust a legislature with such powers, and, therefore, it cannot be presumed that they have done it. The genius, the nature, and the spirit, of our state governments, amount to a prohibition of such acts of legislation, and the general principles of law and reason forbid them. The legislature may enjoin, permit, forbid, and punish, they may declare new crimes, and establish rules of conduct for all its citizens in future cases, they may command what is right, and prohibit what is wrong, but they cannot change innocence into guilt, or punish innocence as a crime, or violate the right of an antecedent lawful private contract, or the right of private property. To maintain that our federal, or state, legislature possesses such powers, if they had not been expressly restrained, would, 389*389 in my opinion, be a political heresy, altogether inadmissible in our free republican governments. All the restrictions contained in the Constitution of the United States on the power of the state legislatures were provided in favor of the authority of the federal government. The prohibition against their making any ex post facto laws was introduced for greater caution, and very probably arose from the knowledge that the Parliament of Great Britain claimed and exercised a power to pass such laws, under the denomination of bills of attainder, or bills of pains and penalties, the first inflicting capital, and the other less punishment. These acts were legislative judgments, and an exercise of judicial power. Sometimes they respected the crime, by declaring acts to be treason, which were not treason, when committed *. At other times, they violated the rules of evidence, to supply a deficiency of legal proof, by admitting one witness, when the existing law required two, by receiving evidence without oath, or the oath of the wife against the husband, or other testimony, which the courts of justice would not admit. At other times they inflicted punishments, where the party was not, by law, liable to any punishment, and in other cases, they inflicted greater punishment than the law annexed to the offense. The ground for the exercise of such legislative power was this, that the safety of the kingdom depended on the death, or other punishment, of the offender, as if traitors, when discovered, could be so formidable, or the government so insecure. With very few exceptions, the advocates of such laws were stimulated by ambition, or personal resentment, and vindictive malice. To prevent such, and similar, acts of violence and injustice, I believe, the federal and state legislatures were prohibited from passing any bill of attainder, or any ex post facto law. The Constitution of the United States, Article 1, Section 9, prohibits the legislature of the United States from passing any ex post facto law, and,